So, we've been having this problem, as folks know, but I've got Gwen on the phone too, so she needs background, where the courts, after the Bailey decision in August of 2011, the courts recognized that it has been settled law for a long time that you have a right to challenge whether the party that's trying to evict you has title to the property if there has been a foreclosure. Now, law, like everything else, responds to what's going on at the moment. And so what seems to have happened is there was a bunch of law that got put in place when the American Revolution happened around foreclosures, because they were coming out of a foreclosure crisis. The same thing happened somewhere between 1840 and 1865. There was another foreclosure crisis. So when you look at the law, there's a bunch of legal cases decided by the SJC during that period, which is what tells me there must have been a foreclosure crisis, because there's a bunch of decisions. The next time there seemed to have been foreclosures was probably shortly before 1900 through the Great Depression. There were short periods, and then the Great Depression itself, which was a longer period. And for those of you who've heard me talk, you know that the Great Depression compared to now was a walk in the park. So there aren't that many decisions from then. So when the courts look for legal precedents and for what settles the law, they're looking back over time. But it means that for this issue, you're looking back 80 years for the decisions from the Great Depression, which there weren't very many of. So you're really looking back 150 years or 200, and 250 years, whatever. It's been a long time. So what they teach in law school is things that they think you're going to have to know, right, as a lawyer or as a judge. And so areas of law like foreclosure that appear, in
waves.
Great detail, but in very far apart waves, nobody studies. And so when the SJC started making rulings, they're reaching back 150 years to make these rulings, but the judges in the lower courts don't have a clue. They didn't learn it in school. There was a little bit of a foreclosure crisis in the 1990s, and that's where we got the Great Dime decision from, but there are no other decisions I've ever looked at that were from the 1990s. And I think part of the reason was because although the foreclosures were bad, they were in a relatively small part of society. They were seniors, basically. It wasn't, obviously, even compared to the Great Depression, it wasn't that many foreclosures. And so none of the present lawyers or judges have a clue. So whatever the SJC is digging out of the dark recesses of the law and putting out a decision on, nobody knows. So when the Bailey decision was made, they said, hey, look, this is settled law. There's no question that if there's a foreclosure and then somebody's going to be evicted, that they have to be allowed to challenge the title of the party that's done the foreclosure. So what happened was that in the Bailey decision, the SJC went back and pulled out these old decisions and say, look, there's never been any other decision. This is the decision. This has always been the decisions that were made. But the problem we have is that the present judges don't know how to think about foreclosure stuff in general. They've got the wrong headset about it. And most of them we're doing in courts that deal with summary process. And summary process is mostly about what's in law is called equity. So there's law that's based in the actual sort of language of the laws or the rules, that's based in the legal decisions that have been made. And then there's law that has to do with trying to figure out what's fair. Housing court judges have dealt mostly for quite a number of years now in what is fair. Which one would hope would mean they'd be less prejudiced about things, but as we're finding, when you dig deeper, that's not necessarily true. But fairness, so what they tend to be dealing with, right, are these questions that don't have to do with the strict interpretation of the law, have to do with what would be fair, right? So, I always say the most common case that comes in front of a judge who's dealing with summary process is the landlord hasn't gotten paid, they want to kick someone out, and the person they're trying to kick out hasn't been paying, often for a reason, right? Something's going on. And so the judge is there trying to decide, is the reason, like, oh, you don't have water. Well, that's a legitimate reason not to pay your rent, right? So the judge is basically trying to figure out what's fair. They're not looking at the strict letter of the law. Their case after case after case has to do with trying to figure out, you know, they're both to some extent in the wrong, who's more in the wrong, who was exerting their rights, who wasn't exerting their rights, whatever. It's not about reading the detail of laws that might be 150, 250, 300 years old. So what has happened is, instead of them doing what they're supposed to do, which is you look at the law first. If the law doesn't give you a direction, then you look at equity. So you're supposed to first say, oh, the law says that, you know, Janet has blue eyes and Chris has, I don't know, gray eyes, and the gray-eyed folks are supposed to get treated this way, and so we know this is what we're supposed to do. Instead, they've been jumping over looking at the law and just going straight to what they think is fair. Well, this is not an area, foreclosure is not an area that has to do with what's fair until you have disposed of what's legal. And what we know is the banks have done everything illegal under the sun, so they should never be getting to the questions of what's fair. Instead, they jump straight to what's fair and they say, well, this bank hasn't been paid in 5 years, and so this person must owe them money, because that would be fair. The fact that the bank has no right to any of the money, that they, you know, basically stole the mortgage because they signed for MERS and nobody's on the other side to make sure what's going on is legal, they never got the mortgage, they have no right to any payments at all, is not where the judge is starting. The judge is starting with, well, you were supposed to get paid, you were supposed to be paying, this is what's going on. So when it comes to the Bailey decision, it's very clear saying, look, you have a right to challenge the title. Now, we all know this, right? Because we're thinking, well, what makes sense? You can't evict somebody if you don't own the property. So obviously, first, you got to figure out who owns the property. That's logical. But the judges are looking at it as, well, what's fair here if you spent $300,000 buying this property at a foreclosure, and you weren't paying the bank anyway, then, you know, you just spent all this money, and it was legitimate, of course, because you signed a contract for your mortgage, so you should have been paying, blah, blah, blah. They go, oh, the third party that purchased just put all this money and energy in, you haven't put any money in, so you must be the one that I should be paying attention to because you just spent this money. So that's one scenario where we get into trouble, because they go straight to equity and they're not dealing with the fact that the foreclosure was illegal and you never purchased anything or anything of that kind. The other scenario is where the party that's in the court is a tenant. And the bank purchased back, right, but the court is saying, well, you're a tenant, you know, you didn't pay the mortgage, you know, you didn't whatever, and now they claim they did own the mortgage, and so they must be right because they're the bank and they put all this money in and you're just a tenant, blah, blah, blah. So instead of thinking about the law, which says strictly, was the foreclosure done legally? If it's not done legally, all bets are off. It doesn't matter what happened after that, because it's too late. The transaction was already void. It never happened by law. It didn't exist, so it doesn't make any difference.
So if the foreclosure, at the foreclosure, they don't have the right to sell that house, then...
Right, it doesn't matter who bought it, because they didn't have a right to sell it. But these judges are not starting from the law. And the thing about real property law is it's funny talking to... anyway, in terms of real property law is incredibly strict. Some of you heard me say this. One set of rules. It has to be sold by the grantor, has to be the person who actually has the thing they're selling. It has to be done in writing. It has to be sold to a particular party. It has to be signed and notarized. That's it. That's the rules, period. One set of rules. And most property transfers don't happen in court, right? You purchase at a closing. It never goes to court. Chances are any title on any piece of property in Massachusetts hasn't seen a court deciding who owned it for 150 years, maybe more. So traditionally, it has nothing to do with judges. It has nothing to do with someone having to weigh the values. It's a set of rules, and you either followed it or you didn't follow it. And that's it. The whole ball of wax. But the judges don't start there. So for instance, and I'm just telling this story because I'm hoping they're going to be here in a minute, I asked Tom what happened with Wilbur on his appeal for his cash bond, right, to try and move forward with the case. And Tom said to me, although actually it turns out the decision's better than what he thought it was, but what he reported from his experience arguing it, Tom Vaughter is who I'm talking about, Gwen, sorry, Tom Vaughter.
Steve Wilbur's case?
Yeah.
Oh, good.
His experience of it was that the judges, he said, went straight to equity. He didn't look at the laws that say, I mean, no one should be paying a cash bond, because the law for the cash bond says that you're paying for rent all the way back to the date when the foreclosure happened. That's supposed to be the basis of the amount that they're charging you for the cash bond. Would any of these banks have accepted rent from anybody? So how could you owe rent? You couldn't owe rent. They wouldn't have accepted rent. There was no rent for you to owe them because they wouldn't have accepted it anyway. So there's no basis ever for a cash bond. It's just not possible. I mean, it is true that Freddie will accept rent. So I suppose if it was a Freddie case, they might be able to argue that they would have accepted your rent if you'd offered it to them. But in most cases, even Freddie won't.
So what happened with Steve's case?
It's complicated. I'm going to... he got rid of the $17,000.
Oh, that's what I want.
No, actually, I don't know that. I'm thinking about something different. We don't have the outcome yet on Wilbur's case. We have an outcome from a different Carhart case where he got rid of the cash bond because he said people couldn't owe the cash bond. So let's hope he does that for Wilbur. Anyway, so how was I talking about that? Oh, because even there, the judge goes to what would be fair, right? And that's not fair, because you can't owe somebody who stole your property money. Right? It's just not possible. So they haven't connected the dots. All right, so we need to find out how close they are. Let me see if I can reach Lori.